Okay, some people have asked me to talk about expert witnesses. Now, just to let you know, before I start, I'm at a place called St Karen Talks Church, and there's a talk afterwards, and you know how nerdy I am about things like this. So I'm going to do the video very quickly and then dive into the talk, and then everything I tell you about the church I can then correct in a future video after I've actually learned what I got wrong. But experts generally, okay, what do we need to know? Basically, what is an expert? An expert witness is somebody who gives evidence about something that isn't within the normal competence of your average layperson or judge. So it has to be a field where people's everyday ordinary experience doesn't come in. So that could be something like scientific evidence, you know, like DNA or something like that. It could be how a computer system works. That's going to be very relevant in a moment for obvious reasons. But if it's just something that, you know, ordinary people might know about, and people are presumed to be quite smart, then you can't call an expert. Oh, there's a nice big cat over there as well. You get experts in civil and criminal proceedings. They're governed by Part 35 of the Civil Procedure Rules and Part 19 of the Criminal Procedure Rules. But effectively, they impose the same duties. So an expert, even if they are instructed by one particular party, they don't owe a duty to that party. Their primary duty is to the court. They specifically have to be objective. And they are told it doesn't matter who's instructing you, you have to be objective and neutral. And when they put in they'll put in basically a witness statement to start with, and also they might have an expert's report. But within that statement, they have to set out, first of all, their qualifications. You know, why are they an expert in this relevant field? And the expert has to be somebody, you know, who can speak on that particular topic. The mere fact somebody's an expert in one field doesn't qualify them to speak about something else. Do they have to be accredited or qualified in some way? Actually, in the UK, no, they don't. I mean, there have been cases where people are just, you know, enthusiastic hobbyists or amateurs, but they've built up such an expertise over time that they're held to be experts. And, you know, this is something that the court can examine. I mean, this is why you set out, you know, how you claim to be an expert. Now, interestingly, in the US, they have two tests for experts. They have the Fry test and the Daubert test. Now, just to give you an idea of how complex case law is, there is a very good argument that they're actually not any different. But to oversimplify and probably get it wrong, and all the American lawyers are probably like just face palming now and head desking, do you look at their paper qualifications, or do you look at their real qualifications? You know, actually, what's their experience? Now, you may be familiar with the excellent film My Cousin Vinny, a film very popular with lots of lawyers. And in that, some lass comes along and she's asked a question about motor vehicles. And she said, oh, it's a trick question. She's asked about the timing settings on a particular car. And she said, oh, that's a rubbish question, I can't answer that. And they go, ha ha, you're not an expert. She goes, no, because that engine wasn't put in that car. But however, if you were meant to say such and such model, then the correct timing would be. And what's really interesting about that is, because My Cousin Vinny, it's not just a brilliant film, it's hyper accurate in terms of legal procedure. And there she was satisfying the Fry test. She was basically going, yeah, I have expertise. I'm not a professional. I'm a professional mechanic. I might not have any paper qualifications, but you know, my experience is such I can speak on this. Now, one interesting thing about experts is, unlike lay witnesses who have to be witnesses of fact, they can only talk about things from their own personal experience and things they know personally. Experts can give opinion evidence. And they can say things like, in my opinion, say for instance it's a medical negligence claim, in my opinion this procedure was carried out negligently. Whereas your lay witnesses can't do that. I mean, say for instance it's just like a traffic case. A lay witness, for instance, can't say the car was speeding. Only a qualified person with all the properly calibrated equipment could say that. Although There is a way around that, because we often say things like, well, without saying exactly, what was your impression of the other person's driving? Oh, I thought they were driving rather quickly. But yeah, you do your expert's report, you set out, your qualifications, you set out the facts upon which you are basing your opinion. And you have to explain what the sources are. Is it something in your personal knowledge? Say, for instance, you're a psychiatrist. Did you actually interview the relevant person yourself and conduct the tests? Or are you looking at the reports that somebody else did and drawing your own conclusions from that? Experts can speak about hypotheticals as well. They can say, well, if it is the facts, because it's not for them to determine the facts of the matter. But say, for instance, they can say, well, if the facts are this, then my opinion would be. If, however, the court finds or the jury were to find that these were the facts, then my opinion would be this. They have to explain, what's within their knowledge. They have to explain what authorities they've done, what research they've done, what books they've looked at, what articles they have considered. I mean, there was a recent case where some guy he didn't put any of his citations, and when the court said go away and do a follow-up report, it came back and it turned out he just basically looked at Wikipedia. Interestingly, although experts, are experts, they are not determinative. They cannot give a conclusion, and courts are told that ultimately the final decision is for the decision maker, whether that's the judge or the jury. So actually, even if all the experts agree, the court can ignore that. That happened in the, remember Peter Sutcliffe, the Yorkshire Ripper? Both the prosecution and defence psychiatrists said this guy meets the legal definition of insanity. However, the judge said, I don't care, I'm going to stick it in front of the jury and let them decide whether he was sane or not. I mean, interestingly, I spoke to somebody actually who was involved in that, and he said that Peter Sutcliffe was an insane guy who thought he was a sane guy pretending to be an insane guy. But this also cropped up in that Nottingham stabbing case, where actually both the prosecution and the defence expert said this guy is insane, and the judge said, I'm going to accept that. I'm not going to let it go before a jury. I'm going to impose a hospital order. And that was the controversy about that said, well, no, maybe it should have been stuck in front of the jury for them to decide. Because, they can base on their own experience, see somebody give evidence if they're giving evidence, and sort of just, go, well, actually, no, I think this guy did know what he was doing at the relevant time. Sometimes we have single joint experts. That crops up a lot in civil cases, where instead of each side producing their own experts, the judge will say, okay, there's a matter here that genuinely needs expert evidence, but decide between yourselves one expert that you both is going to deal with this on behalf of everybody. Because like I say, the expert's meant to be objective and neutral, so it doesn't matter which party calls them. The procedure there is where the judge will say something like, okay, each side suggests 3 names of an expert, and we'll see if there's any overlap. And see if, because if basically they both put in the same people, you say, okay, we'll just have one of these. If in the end the parties can't agree, the judge will say, right, I'm going to decide who the expert is. It's 6 o'clock. So you can also have single joint experts in criminal proceedings, not usually between the prosecution and the defence. However, if there are multiple defendants, they might say, you're getting one expert between you. How does it actually work in practice? Well, you put a letter of instruction in and you say, dear Mr. Expert, this is what we want you to determine. And you'll set out questions for the expert. The expert will report back. There's usually a procedure saying, if you've got any follow-up questions, you must submit them within 7 days of the report, and the expert can answer them. And you've got to copy in the other side and the court, just so so that everybody knows what's happening. Sometimes, I mean, generally speaking in court cases, as you know, one side goes first, their witnesses give evidence, the other side cross-examines. If it's a single joint expert, it doesn't really matter when they give evidence. But now with multiple experts, where each side has instructed experts, we have something called hot tubbing, where basically you'll have 2 experts or however many experts, and you'll just have them sat there and they can comment. You'll ask one expert a question, but then you'll say, what do you say about what he's just said or she's just said? And it's more of a sort of round robin thing, because it's just considered that that's quite often a better way of actually getting the information out there. Can experts be liable for getting it wrong? I mean, generally speaking, you've got absolute immunity if you're an expert. You can't be sued for defamation. The idea being that people should be able to give their evidence freely without worrying about, the consequences of being sued down the line. However, there is a slight difference for experts in that you can't sue them just because they are negligent. In other words, you disagree with their opinion, or even, people go, yes, their opinion was rubbish, they got it wrong. However, there have been cases where experts have clearly just not done their job. They've gone away, they've not even produced a report that's addresses any of the questions, and in that particular case they said actually you can sue them. It's not so much negligence, it's more breach of contract. They were paid to do a job, and they just failed to do it. But yeah, that's that's the general sort of concept. Like I say, there's no great magic or mystery to this, but the key things to remember is experts can give opinion evidence, but their evidence isn't binding on the decision maker. So ultimately, even if they say, well, yes, in my opinion, this procedure was carried out negligently, even if every expert agreed on that, it would still be open to the judge to say, I don't care, I find that, I disagree with you. And it's the same in criminal cases. All the experts could agree that somebody, met the legal definition of insanity, but assuming the judge has allowed this to go to trial, then the jury can disagree with all that. But this is all going to be very relevant, like with that Mr. Jenkins in the post office, where he put himself forward as an expert. And there has been a bit of a thing where they say, well, no, we never said he was an expert. We said he was a witness of fact. He wasn't giving his opinion as to whether the system worked. He was just commenting on matters of fact as to whether there were any error logs or things like that. I mean, this is all going to come back and sort of bite people in the behind, I would imagine. So there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. As I said, I'm at St Karen Talks. I'm going to go inside. It's an absolutely stunning church, this, so I'm now going to go and find out more about the history of it as opposed to my Googling. And did you know I'm actually using notes today? And I am now going to tear these notes up and scatter them to the wind. And you might be going, but Alan, I thought you were one of these eco-friendly, woke, SJW annoying hippies, and I am, but this is special paper. This is plantable paper. It's actually made out of wildflower seeds. So I'm just going to throw it in a hedgerow and they will all grow. And that satisfies two things, because A, there's all my GDPR compliance in that I have now disposed of any material, but also I had some emergency surgery a while ago, and they treated the wound with Manuka honey. And being a vegan, it was like, oh, I can't use honey, I can't use honey. They said, well, it's up to you. You can either use the honey or die of sepsis. So I did go with the honey. But I felt so guilty. I've been planting pollinator seeds everywhere to sort of make up for the bees. And this is one way that I can do it. So now to dump in a hedgerow.